Okay, well, good morning again to everyone. We're very happy to have you in this series of webinars that we at González Calvillo are organizing. Yesterday, we had the first of this one in Spanish. We had more than 150 people there, and it was very productive. A lot of questions were raised in this very important and particular topic that we will discuss for the next 90 minutes. For this English session, we have less people, so we would like you to post questions during the course of our conversation, because we're trying to manage this webinar as a conversation with Luis Enrique Cervantes and Alfredo Chavez. So please feel free to post any question in the chat box at any time. And likewise, if you want to raise your question, you will be able to open your camera and your microphone. Just raise your hand by using the relevant function in this platform, in this Zoom platform. So you can do it either way, and please feel free to raise again questions at any time. So, well, welcome again. We're very happy to have you. Before we start, just a very brief description of who we are. We at González Calvillo, we are a law firm, a full service firm based in Mexico City. With main practice areas in corporate, transactional, M&A, labor, IP, real estate, energy, finance, compliance, antitrust. So we try to work always internally by using the best resource that we have for the benefit of our clients. And in this particular occasion, we are very happy to have Alfredo Chavez, a partner of the corporate, transactional, and real estate practice, together with Luis Enrique Cervantes, counsel of the firm, who heads our labor practice group. And the reason of this webinar is to talk about the recent amendments to the federal labor law, the social security law, and other tax-related laws, which have to do with the prohibition or forbidding of the outsourcing regime, or the possibility for companies to hire outsourcing services. So we have shared with most of you some client alerts, which explain in general terms the content of this amendment to the laws and what the goal of them are. But there are several specific topics to talk about. And we know and we understand that several questions have, arisen because of these amendments to the law. And that's the reason to have this webinar. So again, welcome. And with nothing further to say, I would like to start by asking Luis, what's the main purpose of this amendment? I mean, because we all know that, and what we have heard is that now the outsourcing regime is prohibited. But we also have heard about the term of insourcing. We know that lots of companies have this scheme where they use an operating entity and a services entity. So can you explain to us the difference between that and what's the main purpose of the amendment to the law?
Yes, Jorge. Hi, everyone. Thank you for joining us. First of all, I would like to say that we need to first understand what these amendments are trying to do. They are not regulating outsourcing or insourcing. What they are doing is regulating the subcontracting of services. Usually, in the past, as you mentioned, companies have a service company and an operation company. And this service company could be a third-party company With this said, it's like a company that is not part of the group or is not controlled by the company that's going to receive the services, or through an insourcing scheme, which is that the same group has a company that is the operations company and has a service company that is controlled either by the operation company or by the holding company of that operation company. So that's the main difference of this insourcing and outsourcing. Insourcing is when the service company is controlled or owned by the operation company or the holding company and are part of the same group. And outsourcing, it's when it's a third party that is not related with the operation company that will receive the services. But these two schemes are subcontracting regimes. Okay, so the word to understand and to talk about these amendments, it's subcontracting. And we will say insourcing when the services are rendered by a company that is owned or part of the same group, and outsourcing when the company that is rendering the services is not part of the group of companies of the operations company. So said that in Mexico, what is now forbidden is the subcontracting of personnel. And this is not that companies will not be able to hire anymore or to contract anymore services with third parties or with an insourcing company. This means that if the object of the contract is the delivering of personnel, then that is forbidden because work is not a commercial object according to our laws. So said that, now we will go ahead with what does these amendments allow. And this is the specialized services. And this means that now companies will only be able to hire those services that are specialized. And then it comes another question. How do I know if the services are specialized or not? The law states three main requirements to analyze if we are before specialized services or not. First one is that those services should not be part of the corporate purposes of the company that will receive the services. We usually see what is the corporate purposes of the company in the bylaws of the company. Then, second one is that the services received should not be part or should not be the same as of my main activity or my predominant activity. And this is a specific concept that was taken out from tax legislation. In order to understand this and to know where do I find my main activity and my predominant activity, we need to review our tax submission, yearly tax submission. In that document, we need to state as company from where do I obtain my profits, and we should say in which percentage these profits are coming from that activity. If my profits comes more than 50% from a specific activity, that will be my predominant activity. So in order to understand this, what we need to review is my bylaws for purposes for my corporate purpose, and what are my tax declarations before the tax authorities in Mexico, because there I will state what is my predominant and main activity. And a third requirement is that the company that renders the services should be enrolled before a public registry of specialized service companies. Those are the three only requirements that the law states to understand if we are before a specialized service or not. Two of them are just related with the company that will receive the services, and those are the first two: corporate purposes and main activity or predominant activity should not be comprehended or should not be those or services that you will receive. And the third one is related to the company that will render those services. And there's a fourth requirement, which is not stated in the laws, but comes from a logical thing, and is the those services that are hired or received should be the same that are stated in the contracts. Because if some smart people are saying, okay, we can have a contract by stating that we're going to receive a specialized services that are not comprehended on my corporate purposes and are not my main activity. But in the real world, I'm going to receive services that are part of my corporate purposes and maybe are my main activity. But in the documents, it will be state another thing. That is a very risky thing because we have inspections, and if the labor authorities, the social security authorities, or the tax authorities catch this thing, then they can communicate each other, and you will have liabilities in the three stages. So I think that that will be the main thing to understand of these amendments.
Let me stop you then, because I think there are several things to conclude and to analyze there. So first of all, outsourcing services are prohibited in general, but there are some exceptions. I mean, companies will be allowed to hire what are now known as specialized services under the law. So those structures where there is a company operating which doesn't have any employees, and there's another services entity within the same economic group, and there's an intercompany services agreement between the two of them, and all of the services and all of the activities of the operating company are carried out by all of the personnel hired by the services entity, are now prohibited. Okay, so that's one conclusion, right? Now, now, regardless if it is an entity within the same economic group or not, if the services are outsourced from a third-party services provider, the same prohibition will apply, right? So, having said this, entities now will need to look at their own corporate purpose to see if within that corporate purpose contained in the bylaws of an entity contemplates any activities which had to do with the services that are provided by a third party, regardless if that third party is a company within the same group or a third outsourcing entity. Because those services cannot be contemplated within the corporate purpose of a company. So this means that now companies need to carefully review, one, their corporate purpose, and two, the services agreement they have with any third party. Am I right?
That's correct. This amendment should be reviewed on an internal side and an external side. Internally with my labor structure, and externally with all my vendors and my providers to review that if they can still provide me with services, and second, if they have all the requirements to continue providing me those services.
In the past, Alfredo, we normally, we as a corporate lawyers in Mexico, we normally have drafted, bylaws for several years, and we're used to include in the corporate purpose of an entity a very broad range of activities. Perhaps in the first two or three paragraphs to reflect the main or the core activity of the company, but then to include that the company will be allowed to, invest in several assets and to hire and provide several kinds of services and to do several other things. With this amendment, that culture and that philosophy, if I can use that word, to draft the corporate purpose of an entity will change dramatically, right?
Well, certainly. it needs to change dramatically. First of all, we need to understand that this is a comprehensive amendment. It's not just simply a labor amendment. It implies issues from tax perspective. It implies corporate issues. And this will, I think that now the main issue that we have to identify, both in existing companies and newly formed companies or to be formed, is first identify what you do. Because it's not the same thing to talk about corporate purpose, that it's just a list of issues or things that the company is entitled to do, allowed to do corporate-wise, and the purpose of the company, the main activity that needs to be performed. So you first need to identify what's your main activity, the economic activity of the company, how you're doing that, and what you need to do that. Once you do that and identify that, and that needs to be done with your tax advisors, with your human resources, with your operating people, to identify and clearly understand how you do it, how your process works. And this will take us to another issue, is how the culture needs to change, both operationally and how you leave your contracts. But once you identify what you do and how you do it, then you can turn to your bylaws and start drafting them in a way that you restrict them in such a fashion that allows you to do what you do and how you need to do it, without obviously affecting all other things that you will need to operate that need no human interaction, that, I mean, granting or obtaining loans and credits that you will need to have it, but it doesn't need your human activity. So you have to be very careful depending on how you do it. It has to be a specialized now wording, attending at your activity, and avoid within your bylaws those unnecessary things that we used to incorporate. Like, I mean, we are not providing services, we are receiving services. Don't have in your bylaws that you're going to be providing services. That's not something you will do. So I think that will draw the line of how now things have to be done.
So, and do not include anything that you will really not do. I mean,
of course,
otherwise may place your company in a very important risk, right? So
yes, of course. I mean, we generally included a lot of things that we didn't do. I mean, I've just cited one example. It's we provide services. You're not a service provider. Why you have it in your bylaws? You would have to say, I have the ability to contract and hire services, because that's what I do. I hire third parties to give me services. But if I'm rendering services, then what type of services? Just specifically to the actual services you're providing, and not just a general conception of rendering services.
Great. Then going back to precisely to the qualification of services, if I can use that term, Luis, then what can we how can we interpret that we're facing specialized services or not? I mean, because I think that's a very common question from our clients. I mean, they may say, okay, if I'm a law firm, are my services, or do these services qualify as specialized services? Or if I'm a company providing cleaning services or private security services or IT services or any other services for any other kind of industry, what do I need to know? What kind of information do I need to gather or analyze in order to determine if we are facing specialized services, which in which case that company providing those services will need to be registered with this new public registry that you were making reference to, that will be managed by the Ministry of Labor?
Yes, Jorge, I think that's a very good question. And it's a normal thing that things are very confusing, because if you just go ahead and analyze just the labor thing and the wording, you could be ending by saying everything is a service, and everything that I hire or contract with a third party should be part of this. Therefore, any service provider should be enrolled in this registry, and I should check everything and all the requirements stated in the law. This thing is not that written in stone. Of course, there still be professional services, and there still be exception to these rules of the law. The first exception is that when we are before a service that to be fulfilled does not need that the service provider make available its own employees in favor of the client, then we will be just in front of a commercial agreement or a professional service agreement, but not an agreement that should be ruled by this new amendment. The key word here is that when you make available your employees to render services in favor of a third party. How do we know what we mean with this make available is that, and I will make an example here. It is not the same thing that we hire a company, an IT company, to install or to give maintenance to our server in the company. In this case, the company will make an employee of the company go to our client premises and work on their server or install it. And the work can be done in maybe 3 weeks, maybe a month, a lot of time. And the employee will go all days from 9 to 5 to the premises of the client. But the client will not be entitled to ask this technician, please, can you help me with my computer, or I have my printer is broken. So they are not available for the client. The people that is assigned to that contract are just performing the deliverable of that contract. In that case, that agreement will not be making available employees to the client. The other side, when the contract states that we will provide a technician, an IT people, to be in your premises to attend all your needs from 9 to 5. In such contract, then the client will be allowed to ask the service provider employee to make whatever they want according to the contract. In that way, in such contract, will be ruled by the new amendments because we are making available our employees as service providers in favor of the client. Those are I think that's the most relevant distinction between one thing and another.
Yeah, but basically, and for the benefit of our guests today, at the end of the day, this has to do with payment of profit sharing. Before this amendment to the laws, there was, and there's still an obligation for employers to pay 10% of the taxable profit amongst the employees of an entity. This comes from 1970, amendment to the labor law. But there was a lot of pressure because first, I mean, the government knew, this actual administration knows perfectly that according to these insourcing schemes, companies are legally or have been legally avoiding the payment of this 10% profit sharing by creating this scheme of insert an operating company and a services entity through this insourcing relation. But what this administration wanted to do is to eliminate precisely that. So that is now generating the obligation for most of the companies, and this is going to be another question, to absorb, I mean, for the operating companies to absorb all of those employees which were used to be hired by a services entity. But having said this, I mean, there are a lot of angles that need to be analyzed. One of them is, okay, I'm the operating company, I'm absorbing all of the employees. We'll talk about how those employees could be absorbed according to the amendment to the law and from a corporate perspective likewise. But now what's going to happen with the payment of the profit sharing? I mean, there is this obligation of paying 10% of the taxable profit. Am I going to be still, obligated to pay that profit sharing in that way? Is there a cap to do that? How can it be calculated? What happens with the 2021 profit sharing payable in 2022? I mean, if you can talk a little bit about this, Luis, and then we'll go back to you, Alfredo, to talk about how these employees could be transferred. Obviously, from a labor perspective, Luis can explain that. But then what could be the corporate consequence for the other company that used to act as an employer? Please.
Sure.
Regarding this topic, the profit sharing, it's a main topic in this amendment because, as you state, what companies used to do, and that was the way of doing business in Mexico, in order to control this mandatory profit sharing that hasn't been amended since 1970. They start to work with this structure of in-source company or service companies in order to control the profit sharing. There were not other motivation that to companies to have these structures. The main motivation was to control the profit sharing. But right now, with this new amendment, because that was a very hot topic in the discussion of these amendments, the government and the employers and also the unions make an agreement, and they decide to cap the profit sharing in two ways. First, if the profit sharing payable is more than 3 months of the salary of the employee, then it will be capped to those 3 months. Or if,
sorry to interrupt you there. Is that a base salary or integrated salary? Base salary.
It is the base salary. Okay. And if, because this could be affecting employees in Mexico, because there are a lot of companies, and I'm talking about industry of mining and automotive, they give a lot of profit sharing. For these companies, an employee of these companies could be receiving almost the 50% of their annual revenue within the profit sharing. So for them, it will be a big hit. So what the government and the law states now is that it should be capped to 3 months, or the average of the last 3 years of profit sharing paid in the past 3 years. In that
Whatever
way,
is greater?
yes.
Okay.
The amount that is more beneficial to the employee, that's the amount that you are obligated to pay. So in that way, now the amendment control the amount to pay for profit sharing concept.
Companies. So sorry to interrupt you there, Luis. So companies will need to now make a financial analysis to be certain if I'm an operating company absorbing all the employees that were used to be employed by my services entity, and if I'm going to have to pay them the cap, which perhaps in this particular case, because I didn't have any employees, will be capped to 3 months of base salary, what would be that amount annually? So if I make that analysis, then I will have a lot of, clear future from a financing standpoint, right?
Right. I think that's the key point of the first approach to these amendments. First, companies should carry out a financial analysis to review what are their stages, their scenarios. If my company receives profits that are big amounts, then always my employees will receive those 3 months. And we should carry out a financial statement to say what will be my cost for complying with these amendments. And if operational and financial, I could go ahead and still be profitable in Mexico, then it's the best way to comply with the law. Absorb your employees and pay and comply with everything 100%. If after this analysis, operationally and financially, you will not be in a good position to still doing business in Mexico, then you should analyze other options to comply with the law, but maybe not having this base or operational employees to make them to be less employees instead of all the employees that you actually have now.
Okay.
This sets a little bit of a mind change also in the way you do business themselves, right, Luis? I mean, it is not only on how your business, you have to forget about the idea of, well, this is the model that I had and this is the model that works. It also implies that this amendment is forcing you to review in itself your economic and financial model to accommodate to the actual needs of the reform.
Yeah, definitely. I agree with you. And now that you are making reference to that specific point, perhaps, Alfredo, it would be important also to analyze, okay, this new law, well, it's the same law, but this amendment to the existing law now it will generate the need for those entities who have broken their operation into two entities, I mean, the operating and the services company, to transfer the employees from one company to the other. I think it is important now to perhaps analyze that in a more specific way. What are the mechanisms to transfer the employees? I know that the transitory provisions of the decree that amended the laws provide for certain exceptions, perhaps not to comply with certain requisites to make an employer substitution. Can you, Luis, talk a little bit about this? And then Alfredo, to complement in what could be the corporate consequence for the company acting as employer, well, that used to act as employer, the services entity, please.
Yes. Regarding this transfer of employees from the service company to the operation company, there are the law make an exception with the employer substitution scheme. And first, I will say what is this employee substitution, and then we will talk about what is the exception in the transitory sections of this amendment. First, an employee substitution agreement. It's an agreement that is carried out between the new employer and the prior employer. And in this agreement, they state that from a certain date, the new employer will be in charge or responsible for all the employees' benefits, compensation, and all of the employees' benefits, compensation, seniority should pass to the new employer in the same way. Employees will not suffer any decrease of benefits or wages or anything. That's the main point here. But comes with a good side, that is that since you're not changing anything, then you will not need the will of the employees to accept this change of employer. And in order to do this, the law states that also, in addition to this agreement, all the assets or the main assets of the employer or the prior employer should pass to the new employer to still be able to continue with the services that are rendered by the employees. Those are like the main points of this structure of the employer substitution. But since in Mexico, the structures normally, and 90% of big and medium companies use this service company and operation company scheme, the law and the transitory sections state that for a period of 90 days after April 24, companies can carry out an employer substitution without fulfilling the requirement of the asset transferring to the new employer. So this is a window that the law opens in order to all companies restructure their labor structures and now comply with this law. But this is not the only way to transfer employees in Mexico. We also have a transfer of employees with the resignment and rehiring of those employees with a new employer. In this scenario, the difference is that the old employer should pay all the accurate benefits, and if the employees will be transferred without the recognition of seniority, then seniority severances should be paid to those employees because they are losing that acquired right. But if on the rehiring, new employer will respect and accept the employees with their full seniority, prior seniority, then these seniority severances should not be paid. And those are like the main structures to transfer employees. And those are like the main things that employers are using to make this transference. Other thing that we should take into account is that if we are going to change the benefits or the condition of the labor relationship, the only way we should, or we will be able to do this is with the second option. And with this, I mean with the resignment and new hiring of the employees. And in this new hiring, we can change these labor conditions in order to maybe adapt this specific topic of the profit sharing, that now it will be mandatory for them to receive up to 3 months, and we can make a decrease in other benefits such as performance bonuses. And so if we're going to do that, we should do these transfers through the termination and rehiring of those employees. But in this scenario, we'll need the will of the employees to accept these new conditions.
Seems like then the less complicated manner perhaps to transfer the employees would be through an employer substitution, right? Which implies then the entering into this employer substitution agreement between the two entities and providing notice of that employer substitution to all of the employees. So if that will be the case, then we will have the operating company now absorbing 100% of the personnel of an entity, of all the human resources. And then we have a shell company, but perhaps keeping some assets or not, we don't know, and having some financial results that may be used for the, may be useful for the operating company or not. So, Alfredo, what would be the options then for that entity that used to be the employer, which will have no employees and will have nothing to do basically from a business perspective?
Yes, sure. I mean, we're talking about maybe 3 scenarios or 3 alternatives. One in itself, I think it's the only way to actually be used to transfer employees, which is the merger of the company and the transfer of the employees as a result of the merger, which where I will, maybe dedicate a little bit more of time because it's what might present some complications. The other 2 alternatives, more than alternatives, are consequences. Is once you have your company with no employees, then you have 2 alternatives. Is you either dissolve and liquidate that company, or you can still take the alternative right now, limited to 2 years, to suspend activities of that company. And at the end of those 2 years, then you will have to decide whether you merge it or you dissolve and liquidate that company. But I wouldn't, detain myself with those 2 basically, because those are consequences. The employees are already gone. Then you're left with a shell company that would take a decision. It's important to note, there is really no time. The law doesn't provide you in this amendment with a requirement to complete this within 3 months, 6 months. It has nothing to do. It's just a tax consequence. When dealing with the merger, what has to be considered is, yes, it's an alternative to actually transfer the employees, but the timing involved in a merger has its complications. First, because in principle, starting point is the merger will only affect or be effective upon registration thereof with the public registry. But within that time, you all have the alternative of any creditor of the company opposing to that merger. Imagine then you will not be able to complete that merger until a court resolves of that opposition, if somebody effectively comes. If not, just by the simple time that it will take the public registry to do that registrations in any place in Mexico, as you all know, it will certainly not be in time to meet the requirements of the law to comply with the labor aspects. The other alternative that you have is to make it immediately upon doing that, but then you have to declare all of the debts, not only of the service company, but of the service company and the operating company that are being merged, due and payable immediately. So imagine all of the contingencies that can bring into a company. So our suggestion from the corporate perspective would be transfer the employees based on any of the 2 alternatives that Luis Enrique mentioned, employee substitution or firing and rehiring the employees, depending on what your particular needs or preferences are, and then deal with the corporate consequences. Then we will work on of the merger, liquidation, and the merger will only come into real need if there's a benefit in the company that you need to absorb in the new company. Otherwise, or if there are assets that you want to transfer as part of the of that. But generally, operating services companies have no assets or the employees, so that would need to be addressed in a second stage. I would suggest.
But basically, there will be no rush. I mean,
no,
there is a rush to make the transfer of the employees according to the transitory provisions of the decree that amended the laws. But there will be no rush from a corporate perspective, either to liquidate the services entity or to merge that company into the operating company, right? So
none at all, none at all.
But at the same time, I mean, even though there will be no rush to do that, at the same time, I think that business people will need to pay some attention to this in order not to duplicate administrative and other related costs for maintaining the two entities, right? I mean, at the end of the day, the services company will need to continue having its own accounting and filing tax returns and taking care of some other administrative matters. So it is something that will finally need to be solved perhaps in the next 6 months, but with no rush.
That's correct. You need to take care of it, but not immediately. I mean, you should focus on transferring the employees, getting your contracts reviews and all of the operating real issues, and on the sideline work on the corporate resolution of what you're going to do with your services companies.
Great. So the name of the game now is labor, but I think there's a very important ingredient, if I can say, in that respect, and I would like you both to talk a little bit about that. I mean, I think a question that has been raised several times is, okay, can a company exist without having employees? That's a question that has been raised. I mean, I'm a Mexican subsidiary of a U.S. entity. I have no employees. I outsourced all of the activities that I carry out in Mexico through different services providers, not only lawyers and accountants, but perhaps some other people. Perhaps I hire someone as a freelancer that takes care of the sales of my company. If that can be the case or not, do I need to amend my bylaws? Do I need to review the agreements that I have with my agents, with my sales representatives in Mexico that are not my employees, because I don't have any payroll? I mean, I do everything through my accounting firm or through an outsourcing services provider. I mean, because I think that's the case of several companies, especially US or foreign entities doing business in Mexico. So I would like to focus a little bit on that and analyze that from a labor and from a corporate contractual commercial perspectives. If you can, please go ahead, Luis, and then Alfredo. I mean, feel free to jump in. I mean,
thanks. There is no prohibition to have no employees. There is any regulation in Mexico that forbids you to operate without employees. Nevertheless, there's a lot of prohibition that states that you are not entitled to operate your company if you are subcontracting all the employees that are relevant or needed to fulfill your activities. Let's say this: if my activities can be achieved without having the availability of an employee or any natural person, then you can still doing business without employees, because there's a lot of companies that are managed by their shareholders, and shareholders are not employees. Therefore, there's an example in which I don't need employees because all the shareholders perform the activities that are needed to achieve the purposes of the company. Let's talk about a real estate company that their only activity is to celebrate leasing agreements for that real estate that is the asset of the company. In order to do that, if you want to lease a building, you only need to have a contract and the authorization of the powers of attorney that are enough to sign that contract. And that's the only thing that you need to celebrate a lease agreement. You have the building or the object of the leasing, and to celebrate a leasing contract with the leaser.
Let me stop you. Let me stop you there. Let's talk about then a real estate developer. So my main activity is to purchase a real estate assets and to lease them for commercial or similar purposes. So then I will need to be very careful in drafting my corporate purpose to pull out any type of activity that has to do, let's say, for example, with the maintenance or with the security or with hiring of insurance, for example. So if that will be the case, then I will not contemplate in my bylaws those activities, and I will be able to hire those services from a third party, right?
Yes.
In those agreements, then Alfredo, what do you think? I mean, how can I structure those services contracts so I can take care of not breaching the labor restrictions, but at the same time to keep on my and be certain that my services provider complies with the law and that will not put me in risk if he or she violates these new amendments to the law.
Yes, two things or a couple of things there. First, as I was saying at the beginning, you need to identify what your core business is. And if your core business is simply own and lease property, have your bylaws say that and avoid, for example, it was very common to say buy, construct, maintain, do a lot of things with real estate. No, if you're not doing that and you want to hire those services and subcontract them, then just have your bylaws be like a holding company of shares. What's the purpose of my company? It's just to hold assets and lease them. That's the only thing I'm going to do. Lease them and sell them. That I don't need any employees to do that. Maybe myself as the owner, I'm going to address all of those issues. I don't need any employee. Then you will have to focus on your bylaws. That's the reality. And then the other thing is you will have to have your contracts incorporate those provisions where you clearly identify that maybe the contract you're executing is exclusively for maintenance service. And that is the service that's going to be provided. They're going to send you some people to maintain the equipment, make the repairs that are needed on a timely basis. But that company will report to the service provider, not to you. You're not going to be the one addressing the employee saying, you know what, fix this, do that, because then you're breaching the contract. And obviously now that could take you to all of the other provisions that you will need to take care of your contracts. Maybe we can talk a little bit further about this. I mean, all of these indemnity provisions, very strict wording, the new culture that has to be done in the living in itself of the contracts. I mean, giving this capacitation or training your employees to this new culture in how things need to operate now.
And Alfredo, just to add, and I think that it's going to be a very rich thing to say now, is what are the consequences of not complying with these new regulations? And for these purposes, the main consequences not come from a labor perspective. They come from a tax perspective, because taxes are the way that we're more affected with these old schemes that were abused by some companies in order to not pay taxes or to evade the payment of taxes through this structure of subcontracting and without receiving the services. So said that these amendments state that if you're not compliant with this regulation within the subcontracting of specialized services, then the receiver of the services will not be entitled to transfer the VAT, and also will not be able to make deductible the payments made to the service provider. Therefore, it's a big hit to the client of those services. And the other thing is that...
Hold just 1 second there, Luis. So just to be certain, if I am the company beneficiary of the service, receiving the service, and there's a breach on the part of my services provider of these requisites that we have been analyzing, then I have a very important sanction from a tax perspective that will consist in one, not being able to credit the value added tax that I will pay to my services provider. That's one thing.
Yep.
And the second one is that I will not be able to deduct the payment of that fee to my services provider for income tax purposes. That's the second one, right? That's huge. That's huge. Okay.
In addition, you can also be liable for fines of the labor authorities that are not cheap. Fines are between the range of $9,000 and $224,000. So we're talking about big amounts. And the thing here is that not only the service provider will be liable for these fines, also the receiver of the services will be liable for these fines. So the fines are in both ways, for the receiver and for the provider.
Yes, we can't forget that even when this reform is dressed up mainly as a labor reform, I mean, one very important factor behind it is the tax evasion controls that they wanted to do. So yeah, it might have been done with the tax view or justification as the front, but the reality is that it has a tax implications and seeking to collect more taxes that derive from the misuse of the subcontracting schemes in the past.
And in addition, if the amount of the payment of the services are or are way of a cap that the tax authorities state, the companies are liable for a fraud, a tax fraud. So that's another penalty that it comes more from the prime perspective and all that in addition of the other ones, what the government and the law is now, it's a shark with big teeth.
Yeah, which is, if I correct me, I'm not a criminal lawyer, but I mean, this tax evasion is considered a serious felony to the under the same degree as drug trafficking or crimes of that nature.
It's a serious crime. Yeah. Tax, because it ultimately it may qualify as a tax evasion depending on the level of the amount that was evaded. So yeah. So this takes me to then. I mean, every time an entity in Mexico hires the services from a third party, there are several things to be reviewed, right? I mean, one is that those services are not contained in my corporate purpose.
Sorry, I think, Jorge, that the first thing that we need to review is if we are before specialized services that it's under the scope of the labor regulation or not. If we are under a labor scope, then you should review what you were mentioning.
And in that case, Luis, before we go further, then we'll need to go back to our when we started this conversation today. I mean, if according to that services relation, any personnel would be placed to my disposal, if I can use that word, and make available to me, then that will be prohibited or not, but that will qualify as a specialized service. And in which case, then I need to review first that those activities are not contemplated in my bylaws. Mm-hmm. Second, that the service provider is recorded with this public registry to be managed by the Ministry of Labor. Third, I understand that there is information or reports that now the services providers will need to deliver to the beneficiary of the services, to the client, periodically. Can you talk a little bit about those reports of information and what the scope of them?
Yes, a specialized service company right now, they will have to deliver information to Social Security authorities. This information should be delivered every 4 months. And in this information, you need to state who's the receiver of the services, what is the nature of the contract, what are the employees that are assigned to the fulfillment of that contract, and all the social security data of those employees that are assigned to the performing of the services contract by the client. With this said, there is no like a specific obligation of the receiver of the services to ensure that your service provider is fulfilling without all of this. But all the consequences are jointly. Therefore, in a due diligence of that contract, clients should be taking care of the topic that your service provider is fulfilling with all the labor and benefits obligations they have as employers. I think that's a relevant thing. Right now, in the past, if your service provider was not compliant, then it's a service provider trouble, and I should resolve liable, but not in a big way, because the fines will not be against me. Only if there was a labor claim, I will resolve liable. But right now, I'm liable from the day one because fines are joint.
Which I mean, puts clients in a very high exposure. Then, Alfredo, I mean, we normally recommend our clients to create and integrate the KYC file, the Know Your Client file. No, I mean, normally, and I mean, we always recommend this as a good practice and also to comply with anti-money laundering law. But now, because of these changes to the law, I believe that the KYC file will need to be, I mean, bigger, and we will need to put focus on some other stuff, and perhaps also to contemplate in services contracts some other provisions that perhaps we were not including before. Am I right?
Yes, certainly. I mean, for example, we were in your contracts, you generally simply included some indemnity obligations for tax issues, right? I mean, depending on the nature of the contract. Right now, you will have to start incorporating specific indemnity obligations with respect to these fines that Luis Enrique was saying, or these liabilities that we may assume for faults deriving from our service providers. We would have to have a different focus on how we leave the contract. I mean, contracts right now could not necessarily be just, he's providing the service in order. Yeah, he's providing the services in order, but then we would have to focus on his fulfillment of all of these obligations, delivering and requesting this certificate that I understand is going to be in place 3 years, but notwithstanding that it's going to be in a place, it can be revoked. And so we need to make a constant review, asking them for certifications, verifying that this is effectively it's still in place during all of the time that our services are being rendered, so that we're able to prove that we're in order and they're compliant. And if not, incorporate termination provisions, automatic termination provisions, just by the mere fact of the termination of or the revocation of the registration with the ministry immediately results in termination of our contracts. But we have to have this new culture in on the people who manage the contracts on a day-to-day basis to have this new focus. As they have focus on, I mean, payment of taxes. This is a new obligation that you have to have in your operating checklist within the company. Somebody has to have a checklist saying, okay, I need to verify that all my service providers are still compliant with all of these obligations, require proof of delivery of payment of social security contributions, stuff that maybe in the past we didn't care, because as Luis Enrique was saying, it was responsibility of the service provider with respect to his own employees. And we were just generally accustomed to saying, well, okay, you indemnify them if somebody sues me. If your employee sues me, then you indemnify me. Right now, these indemnity provisions have to be broader and more closely supervised in the day-to-day operation of your contracts.
Yeah, I mean, it's a totally new world, if I can use that word. I mean, when reviewing and when preparing services agreements. I mean, for instance, I understand that the validity of the registration of a specialized service provider is for a 3-year term. So we need to be very careful that we request every 3 years to our services providers that deliver to us their renewal this certification or registration. Otherwise, we may be jointly liable. I mean, not only them, but we, I mean, as a client. So yes, so the name of the game again is labor / corporate contractual or commercial, if I can say. So and these places, I mean, everyone on focus. I mean, this reform would apply not only to entities that have these operating / services scheme, but any entity basically doing business in Mexico, because any entity doing business in Mexico does have services providers. I mean, and so now the important thing here is to analyze if those services qualify as specialized services. If that is the case, then those contracts will need to be not only, I mean, reviewed, perhaps terminated, and new ones put to be entered in place of the existing ones. So, I mean, there are lots of things to do. Obviously, there are companies with this insourcing scheme that will need much more work from a legal labor operating perspectives. So, and I don't know what's your vision on this, but for me, this is only the tip of the iceberg. I mean, I think we're gonna see a lot of things. I think there's a lot of place to interpret the amendments to the law, which will need to be made by the federal courts, and why not by the Supreme Court in the future, by creating a thesis of jurisprudence to interpret the amendments to the law, but this will take some time. So meanwhile, I think we need to focus on all of this. We are above the hour. We've been talking for this topic for more than 60 minutes. I mean, the idea was to leave some room and space for questions. I mean, there's a couple of questions that were raised privately. I will be able to respond to them later after the webinar, especially if we have some information about outsourcing. I mean, I think that we have discussed a lot of things about outsourcing, but again, this is a very broad topic that we can discuss individually later with the audience, if or anyone specifically. But again, if someone has any questions, please feel free to, I mean, either to do it openly by raising your hand or by posting them in the chat box. Meanwhile, I will ask Luis and Alfredo, perhaps just final remarks, just to close this topic and to conclude.
Jorge, before closing, I think that we should point out that insourcing companies can exist within this new regulation, because also the law recognizes that there are some structure in which there is not only one operation company and one service provider company. We have like 10 companies and one service provider company. And in such cases, it's allowed that all the shared services can be subcontracted with this insourcing. And this is how we are going to get these specialized services insourcing companies. And that's a very good news for all the companies that has this type of operation with a lot of operation companies and just one service company. They will be allowed to keep that service company, but this service company will only be allowed to render services, those that are shared within the whole group of companies of the same group. So that's good news too, because the law and the government recognizes this type of scenarios.
That's a good point. Yeah.
Yeah, one thing I would like to say, let's not forget that not all services, and I want to reiterate this, not all services are specialized services. There will still be ordinary services contract that will not be prohibited. As Luis Enrique said, we would just have to focus on those where there's employees put at the disposition of the other, and we would have to analyze if that main basic scenario of the provision is met, and then decide if we have to verify all of these things. There will be elements such as the deliverable itself of the contract, if it's I mean, the deliverable implies no human disposition, then don't care about that. That's not subject matter of this reform. So we have to do a careful analysis, and I mean, based on that, then work towards getting this performed and complied with.
But the line seems to be very thin. I mean, when analyzing that, and that's going to be the challenge, right?
Of course.
So we have one raised hand, and we have a question. So let's go first. If IT, please can open microphone to Cecilia Sarabia. She has a question. Go ahead, Cecilia.
Welcome. Hi, I just have one more specific question. I believe it falls more on the corporate side, but when using the merger as a specific mechanism to comply with the amendments to the law, and specifically as regards to enforceability before third parties after registration, I understand that the law provides for certain exceptions, as Alfredo mentioned. So I just wanted to check if the exception that talks about having all debts of the companies involved in the merger agreed or convened, I believe that's what the article says, is to be interpreted as having them all settled and paid, more than just letting your counterparties know that you're going to pay for those debts and that you're going to settle them, but it could be in the future. My question is if the companies have to have them paid before the merger is enforceable before third parties with that exception.
Well, I think this is what the law says is that you have two options for it to serve immediately. If you have an agreement with your creditors, which agreement may imply that, I mean, the debt is going to continue with a new company, that it's going to be paid within its terms, that no acceleration exists. But remember, the basic premises is that you have to declare all debts payable. So whether you're confronted by your creditors and requested payment, or you reach an agreement, that's totally separate. But in principle, the obligation is you would have to make them due and payable at the time, so for the merger to become effective. The purpose of the protection is to the creditors is maybe you're merging, this might not be the case, but you're merging a company that's very profitable with one who has terrible debts, who's gonna, it's gonna end up with the profitability of a company. So maybe the creditor is gonna say, I don't want you to merge. I want you to pay me, then do whatever you want, because once you merge, there's not gonna be any assets. That's the reason behind it. But yes, in strict senses, they have to be payable. Whether you reach an agreement or not to extend the payment, that's something separate.
If I can add there, that's if you want your merger to be effective immediately upon recording with the public register of commerce. Otherwise, you cannot necessarily obtain the consent of your creditors. You cannot necessarily make those debts accelerator and just wait 3 months after the recording with the public registry. However, if you do that, remember that the Ministry of Tax or the tax authorities are considered to be a third party. So the merger, and therefore all the effects of the merger will not be effective immediately, but you will need to wait for 3 months. So
and also one thing there, but remember also one thing there, Jorge, that during that process, even if you're waiting the 3-month period, any creditor may oppose to the merger.
Yes.
I mean, they could. And in that scenario, your merger will not become effective until a court resolves on the dispute. So then your merger, with our system, could take you 2 years.
Yeah, will be suspended.
Yes, would be suspended, no effects. Then you're not resolving the issue that we have at hand, that it's transferring the employees.
If you're transferring the employees as a consequence of the merger, then that transfer will not take place, and then you will be breaching the amendment to the law. So
yeah,
that's why Luis Enrique has suggested to better transfer the employees through the employer substitution. So there's a question here in the chat box which says, "Hi guys, how this would be applicable to a Mexican entity that receives services from an outsourcing, insourcing entities located overseas?" I think that's a good question, and we have talked about this. Which would be your recommendations, considering that the employees of the outsourcing entity are located in Mexico and they provide services that are part of the core business of the Mexican entity. I think this may be broken into two questions, right?
Yes. First, I believe that that specific structure is very complicated because if the outsourced company is abroad and they have employees operating in Mexico, then first they will be liable because they are not fulfilling with the Mexican labor law. Because Mexican labor law applies to any person that that performs a job under the Mexican soil. So immediately, Mexican labor law will be applicable to this type of relationship. Nevertheless, because then it comes in, what if I hire them with a foreign entity, but they are assigned to perform their work in Mexico? The law states that the law don't care where the labor relationship was hired or contract. For the Mexican labor law, it's where the services are rendered. And if those employees are Mexicans, they will have a double thing to claim here. First, that this foreign company will be liable for all the labor benefits that are mandatory in Mexico. And I'm talking here about social security obligations. They will be liable for that. And all of the other mandatory benefits that are stated in the Mexican labor laws. But let's assume that the outsourced company said, I don't care, I will pay whatever it takes, but I will make that structure work with my clients in Mexico. It will be very difficult because nevertheless, maybe the Mexican laws will be very difficult to apply them in a foreign country. But since your clients are based in Mexico, they will be liable for that contract. Your Mexican clients will not be entitled to make tax deductions with that payments, and not they will be liable also for maybe the fines that are stated in the law.
And it can
one other thing there.
Complicated. I mean, sorry, Alfredo, it can get much more complicated because if a foreign entity is providing services to a Mexican entity with foreign employees, well, those foreign employees will need to have a working visa to be here. And if they stay here for more than 80 days consecutive or not in a 12-month period, that may cost the foreign entity to have a permanent establishment in Mexico for tax purposes. So, I mean, I will never recommend that if that will be the case. I mean, those services will need to be provided outside of Mexico, and then a specific tax treatment may apply to that contractual relation. Sorry, Alfredo, go ahead.
No, that was precisely what I was going to tell you, that from a tax perspective, you would be creating a permanent establishment. From an immigration perspective, you would also have an issue if you have foreign employees. But the same problem would be if you have Mexican employees. I mean, if you hire in Mexico Mexicans, then you will still have the tax implication of having the obligation to register yourself before the tax authorities making your payments. I mean, you can do it through a branch, but then you're not avoiding the application of the labor law. The only way that you would be avoiding it, in my understanding, is if you're rendering the services abroad. That's the only way that it wouldn't be applied.
Or we change the structure of the question. Something that it's allowed is that if you're a Mexican outsourcing company that delivers services to a foreign company, then Mexican labor law will not apply, or these specific subcontracting rules may not apply, because foreign entities are not under the scope of this regulation if they receive the services. Because let's talk about maybe a maquila, which is the foreign entity hires a Mexican entity that could be under the same group or not. And the only thing that are performed is we will deliver the final product, and the product will be exported to the US. But in that case, the benefits are in the foreign entity, not in the Mexican entity. As long as the Mexican entity hires by itself the employees, then that structure could still be legal and there's no trouble in that.
Great, yes, I agree. Thank you, Luis, thank you, Alfredo. The second part of the question is, which would be your recommendations considering that the employees of an outsourcing entity are located in Mexico and they provide services that are part of the core business of the Mexican entity? Well, I think that's been the core part of this conversation. That will not be able or doable anymore, right?
It's a no-go from the start, yes.
Yep. Okay, great. Well, I don't know if someone else would have any other questions. I mean, otherwise, Luis, Alfredo, I mean, any final comment or remark on this?
No, but just thank you for hearing us and participating. And if you have any doubts, comments, or questions, feel free to contact us with them.
And I will say just a closing thing here, and it's that in order to comply with the law, there is not 100% bulletproof recipe here. You should analyze your own characteristics and your own world inside and outside, because there's no a recipe that applies to everyone. So our advice is to please come and first analyze you internally and externally in order to see what is the best option to comply with the regulation.
I agree with you. No recipe in general would apply to everyone. Yeah. Well, Alfredo, Luis, thank you very much. But especially the audience here today, thank you for participating in this webinar. As Luis and Alfredo have explained, I mean, this is a complicated matter. Again, I think we're just taking a look to the tip of the iceberg. So a lot of things are to come. Fasten your seatbelts. And well, thank you very much. And anything you need from us, let us know. Thank you again. Have a good day. Bye-bye.
Goodbye, everyone.
Thank you. Bye.